The HR Stories podcast is brought to you by the team at HR Stories. The team at HR Stories helps businesses, nonprofits, and HR practitioners better manage the employee experience, providing the tools, training, and resources needed to get HR right. For more information, check out our website at theteam@hrstories.com. Each week on the HR Stories podcast, HR and leadership experts John Thalheimer and Chuck Smikian dive into the stories that matter most to you, our listeners. We have found that there is a lesson in every story. And now our host, John Thalheimer and Chuck Smikian. Welcome to the HR Stories podcast, where there is a lesson in every story.
It sounds like the beginning of a Twilight Zone or something, John.
Yes.
Welcome.
I had my what was his name?
Rod Serling.
Rod Serling. I had my Rod Serling voice on. How's everyone doing today? We are here. We are here at the HR Stories studios. And we are talking HR. Chuck, what's going on in HR? What's happening in your world?
Well, we're in the throes of summer. John, I got to encourage all of our listeners, if they have not, and we have thousands of people on this, folks, but our email newsletter, our monthly newsletter, we send out, and you want to click on the links below. Make sure you can get on our newsletter. We offer helpful tidbits, and we're actually sending out, as many of you know, we've written a book, The Ultimate Guide to HR, Checklist Edition, and we are sending out free checklists, John, for anyone that subscribes. We'll pull a checklist, we'll send it out. It's a great deal, and it's free. It's free. So, and we offer great advice and little tidbits and news and, I don't know, the kitchen sink. And free ice cream sundaes.
Yeah. The newsletter is definitely free. Definitely sign up for it. There's a lot of great information in it. And we also talk about the podcast in it. So again, we'll kind of like, hey, this is what we talked about in this podcast. So it gives you some kind of idea of what's happening on our podcast as well. So definitely something to check out. Very good.
Yeah. And you know what else I like about the newsletter? This is something Kay at our social media guru takes care of once a month. If you missed a podcast, she sends out a digest of all the podcasts that we did over the last couple of weeks and said, hey, check it out. And she sends a summary and you can pick and choose. So all great stuff. Click the links below. John, I have talked about this frustration since I have been working back in the chair as an HR director and I'm a big fan of HR technology. I love HR technology when it works. But I've had a frustration with HR technology that years ago, John, when you were a kid, they were rolling out HR technology and they said, look, this HR technology should be so good that it's going to take things off your plate as an HR person, no paperwork, and now you'll automate all these functions or they'll be streamlined, you'll find efficiencies, and now you'll be able to spend more time with the people in the field doing what HR people do best is, managing the human resources. And it's like, wow, that sounds great. And, applications and, some things worked and they did well, but they created other problems. And sometimes I feel like I'm just stuck to the computer all the time with the HR technology. Now, whether it's Paycor, Paylocity, ADP, Workforce Now, Kronos, they have their issues. But I saw a study just came out from SHRM. It's a group called Gartner, and they did an HR technology study, and they talked to a bunch of HR leaders, and they found that HR technology remains a top investment for HR executives, but only a few of those leaders actually believe their organizations are receiving maximum value from the technology spending. And so it's not just me that feels this, it's actually in this survey. And there's a number of parameters here, but one of the call outs that I saw was nearly, and this is a quote from the survey results, nearly half the respondents to the Gartner study reported the use of HR technology solutions has damaged rather than improved HR's reputation across the organization.
Wow.
So if you're a listener out there, we'd love to hear from you. Is that what's happening, or has HR technology improved your reputation?
Yeah, I mean, again, right? I mean, that's what we stand on, right? HR professionals stand on their reputation, and if the system is hurting that reputation, that's not good advertising for the HRIS systems out there.
Yeah, and I will tell you one thing, John: garbage in, garbage out. And we use product ADP Workforce Now. It actually works, but there are fickle things, and if one little thing is off, or we don't do this in this sequence, it creates a whole other big problem. And so, we end up working on that. And of course, it's very easy in my career working with the different HR systems. Oh, it's Paycor's fault, or that ADP system, and so everyone starts falling to that when actually the systems can work, but they're so intricate. And also, a lot of the technology leaders, the HR leaders, felt that the leveraging of these systems are so complicated, they're unable to truly leverage them because the non-technical people can't figure them out. And so I just thought I'd share that with you. Not looking for a lot of back and forth with you on that, but I know you feel that pain from me when I bring it up. So what do you got, John?
Oh, technology, ladies and gentlemen, it is the problem.
Yeah.
No, technology is great when it works, right? And we always say it, when it works, it's fantastic. When it doesn't work, it's there. So, Chuck, you know this, and I think some of our listeners know this as well. I made the big move, right? And so I moved to Nashville. I moved from Nashville, Tennessee, to a small town in Virginia. So I'm excited for that. So if you're in Virginia, definitely reach out to us. I definitely want to meet HR people in Virginia. I'm in the central part near Charlottesville and Richmond, that area. And so I make this move, right? And I was thinking about this, is that when you move from one state to another state, you move your business from one state to another state, you have to think about what are the employment laws, right? And so I'm like, oh gosh, let me go check Virginia's code of employment law. And so they have the Code of Virginia. So it's on the Virginia Law website in the General Assembly. And so Chapter 3 is titled Protection of Employees. And there are there are 5 different articles, right? So there are 5 different articles: general provisions, minimum wage act, assignment of wages, sale of merchandise to employees, paid sick leave, organ donation leave, employment of women generally. Well, that's been repealed, so that's not there. And then safety provisions as well. Wow. Right? And so again, now there's that layer on there. And I was talking to one of my clients, and they're in Tennessee, but they have an employee that's moving out to California. And now I'm like, you're going to have to update your employee handbook, because you're going to have an employee in California. You're going to have to follow the laws and regulations there. And so I think it's really it made me more aware of it, right? Because I knew we talk about it all the time. But then to kind of think about, oh gosh, if I'm going to be working in Virginia and I'm going to be having to do consulting and client work, I'm going to need to know the laws, right? And so how do they apply, and what do they look like? And, kind of going through all that. So I thought that was kind of interesting just to be aware of, and making sure that we're paying attention to it.
John, can I ask you, I know now that you live in Virginia, and you moved from Tennessee to Virginia, your wife now works in Virginia. Does her company have to update those benefits for her. I think so.
Not the benefits as much, but
The paid sick leave and
they
stuff.
already, yeah. So yeah, their leave stuff. They're not going to have to update it for her because there's numerous people that their office is out of DC.
Okay.
And so they have people in Virginia, Maryland, Nashville, Philadelphia. I think they have people in Washington. They have people all across the country. They kind of are pretty much all remote, not all remote, but there's a good portion of them are remote. So they're already playing with that. They're human resources persons all over it. So yeah.
Yeah, no, that's all great points.
But yeah, if she was the one that was moving there, then they would have to update it. But I think they already have that played out in their employee handbook.
Gotcha. Yeah, that's all great points.
Yeah.
You know, I know companies that will not hire employees that are working remotely in certain states. I had a client like that. He said, look, you can hire anyone remotely. They can work in these 5 or 6 states, Florida, Texas, you know, South Carolina, things like that. Arkansas. But we're not hiring anyone that lives in New York, New Jersey, California, Oregon, Washington. You know, the litany goes on. Massachusetts, Virginia.
Yeah.
I don't care how great they are. We're not going to hire them if they live in that state. So I thought that was interesting. And that brings up a great point.
Yeah, I mean, it's just something that we need to be paying attention to and thinking, oh gosh, how's that going to impact us? And do we have policies in place like your company or that company did? Like, hey, these are the places we're hiring. This is, you know, again, all that plays out. We have to be paying attention to it. And then, I mean, we're talking about employment laws. We're not talking about the tax burden and all that, which is a whole nother story.
Yep. So, all right. Well, I have one more thing that kind of feeds into today's big story. And this was, this hit the news, a couple of days ago. It's another FMLA, ADA claims lawsuit. And, you know, manager fired, says I'm fired due to being diabetic episode, things like that. But one thing that stuck out to me, and I've dealt with this in so many places where HR, you've got to hold the line on this. It's the call-off procedures. So this is a store manager for Hardee's, and just to briefly go over it, you know, she says, hey, I was denied leave under FMLA. I was fired because of my diabetes. And here's the story. She wakes up one morning with low blood glucose symptoms and disoriented, and she doesn't go to work or call in that day. Instead, she drives to the hospital for treatment. Then the next day, she sleeps past the start of her shift while she's still recovering. She phones her supervisor to report the episode and emails a doctor's note. The next day, she's still out. She emails the supervisor. Anyways, she's trying to stay in touch. Look, this is what happened. So this company is called Westar. Denies her FMLA request because they said, you know what? You don't work here anymore. You're fired. You can 3 days later, now you're asking for FMLA. No, you were fired the other day because you didn't show up to work. You violated, get this, John, the call-in policy, which requires you to call your supervisor 2 hours prior to your shift.
Yeah.
You know, and it's like, you know, I dealt with a situation recently where an employee called in at 3:30 in the morning, okay, for a 5 a.m. shift, right? 3:30 in the morning. And I got a request to do a counseling because they didn't follow the 2-hour call-off guideline. Okay, so at 3 a.m., you were going to do something different than at 3:30 in the morning? You were going to, I mean, what? Really? It's just funny. So this policy that these folks had and other policies, there's usually a when possible put in there. So, hey, you need to call off 2 hours before when possible. And the when possible thing is you're in the hospital, you're in a coma, you're unable to call off due to some traumatic situation. And that's what this policy had in it. The manager, the owners, whoever said, we don't care, we're firing her. And so now it's going to court. And she's saying it was because of diabetes. So I don't know, HR folks, you've got to take a look at those policies. You've got to hold the line. And I know managers, owners, senior leaders, they get frustrated. They're like, oh, they didn't follow the 2-hour policy. There's other things that got to factor into it.
Yeah, and I would be interested to go back if I was doing the investigation. How have they treated other employees that didn't call in under the 2-hour policy? Were they all like firing, or was this like, oh, we want to get rid of this person because whatever, they're not performing high, blah, blah, blah. That's not the way to do it. You got to go through performance, right? And so we talk about that all the time. I did a class up in Philadelphia this week, and we were talking about there was a employee that was 80 years old and just wasn't meeting the performance expectations. And I'm like, take age out of it. Focus on the performance and then talk to them about the performance. Now, there may be ADA claims there. There may be things that you need to follow through, but you have to focus first on the performance and then talk to them like, hey, you're not doing your job. And I think too many people look for those shortcuts and go, well, they didn't prove it. And then all of a sudden you go through their records and they have every other employee's done it as well.
Yeah, and that'll come up in the EEOC lawsuit. That's the one thing they're going to want to know.
Yeah.
So, all right.
Yeah.
Great stuff. You got anything else to share, John?
Sure.
Johnny T?
Yeah, I got it. Well, I got a couple things, not big stories, a couple things. So, as we predicted here on the HR Stories podcast, the Department of Labor's overtime rule showed up in court. Bum, 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 bum. And so it showed up in a Texas court. And so the Texas judge looked at it and said, no, Department of Labor is overextended. They can't do this. But what he did was, and so there was a lot of people joining this lawsuit, but it was originally from the state of Texas. And so he said, look, it doesn't matter for all these others, but for employees in the state of Texas that work for the state of Texas, the Department of Labor overtime rule, the EAP, the one they just came out with, doesn't work, right? And so you had to go through it. And so they kind of spilled that out there. They went to it and said that. Now, we know that it's going into other courts right now as well, right? Other federal districts, it's going in there, it's popping in there. And so we need to be aware of that. And I'm just telling my clients, I don't know what you're telling your clients, and I'm just telling my clients, Chuck, go do it, get it right, make sure you're doing it, look at the hardship. And if it doesn't really impact you or it's not a big impact, go forward, do it. You don't want to be on the wrong side of this, right? And so again, it probably is going to fall somewhere in there. There's going to be some court case. And with the Supreme Court knocking down the Chevron, I think a lot of people are looking to that going, well, they're overextending. I'm not sure how it's going to end up, right? And so I think it's just something that we need to be paying attention to. But we knew that. Anybody that's been watching this knew that was going to happen. And so something to kind of be paying attention to as well.
Absolutely. Yeah. I'm really waiting to see what happens. I know a lot of businesses have been pushing for this not to happen. So we shall see. We shall see.
Yeah. And I know I say this all the time, and I probably told you 1,000 times, Chuck, but I don't see the benefit of being exempt for an employee, right? And I think the Department of Labor looks at it the same way, and they're like, well, we don't see. So if you're going to make somebody exempt, you better have your documentation of why they're exempt, right? And so again, this is just one test. That we have the minimum exempt salary level, which is what we're talking about. We have the salary basis, and then we have the duties test. And you have to make sure all three of those are clear, good. Yep, that person's definitely exempt. And spend time with it. Make sure you're doing it right.
Yeah, and if you need some extra help, check out the Ultimate Guide to HR Checklist Edition, available from the team at HR Story. Links below. John, let's take a quick break, shall we? Stretch a little, get up and jog around the house a little bit. Okay. But hey, you've been listening to the HR Stories podcast, where there's a lesson in every story. By the way, before we go to our break, I do want to let our listeners know that the HR Stories podcast is looking for sponsors. So if you're interested in reaching thousands of HR professionals, reach out to us at contact us at team@hrstories.com. That's contact us at little @ team@hrstories.com. Hello, listeners. I have some questions for you. Do you find yourself struggling with HR and employment issues? Are you afraid you could make the wrong employment decision that will cost your company thousands or even millions of dollars? Maybe you're new to the world of HR, or you've been in HR for a while and you just wish you had one resource, a guide to help you get HR right. Well, I've got good news for you. The team at HR Stories is excited to announce a new comprehensive resource, the Ultimate Book of HR Checklists. We created the Ultimate Book of HR Checklists as a simple, step-by-step resource guide packed with 70 downloadable checklists and other resources that help small businesses and organizations get human resources right. Even with very little HR or management experience, you can get instant results with concise, practical steps for addressing many of your tough employment issues. Do not miss out. Go to hrchecklist.com to learn more. That's hrchecklists with an S.com to learn more. And as always, thanks for listening to the HR Stories podcast, where the lesson is always in the story. Welcome back. You're listening to the HR Stories podcast, and perhaps you're watching us on YouTube. That's right, folks. We have a YouTube version. And if you are watching, you see this crazy thing sticking out of my ear. For some reason today, I couldn't get John's sound to go, so I had to plug in one of these old-fashioned, like wired headphones, earbuds, right? Wired earbuds that I found. And so if you're watching us on YouTube, which I highly encourage you to do, you'll see me with my crazy little earbud headphones. So what do you think, John? The HR Stories podcast, we're up there. This is episode 83, 84, somewhere up there. What do you think of the HR Stories podcast?
It's my favorite podcast, Chuck. You know that.
I love it.
Do you know what we're celebrating this month, Chuck?
Independence Day, John. It is July. Fireworks, hot dogs, baby corn on the cob.
Yeah, such a great holiday. Oh, a little corn on the cob. I like it. Throwing that in there. Nice. Yeah, and it's a great holiday, right? We all celebrate it. We're going to sell in 2 years. So get your plans together, everyone. In 2 years, we'll be celebrating our 250th birthday. And that's going to be amazing, right? That's going to be a pretty amazing feat when we reach that. But I was thinking of another momentous occasion, one that is also focused on independence, the independence from discrimination.
Yeah, wow. You know, the Civil Rights Act, 1964. I cannot believe it's turning 60 this year. I read that.
Yeah.
And I did
on July 2nd of 1964, President Johnson signed the Civil Rights Act into law, protecting citizens from discrimination on the grounds of race, color, religion, and national origin. It also created the Equal Employment Opportunity Commission to implement or oversee the law. The EEOC enforces laws that prohibit discrimination based on race, color, religion, sex, national origin, disability, age in hiring, promoting, firing, setting wages, testing, training, apprenticeship, and all other terms and conditions of employment.
Woo, woo. And over the years, it has been expanded. I mean, beyond what you just said, right? The Age Discrimination and Employment Act, the Americans with Disabilities Act, the Genetic Information Non-Discrimination Act, or otherwise known as GINA, and of course, the Pregnant Workers Fairness Act. And I'm sure there's more to come.
Well, there's not more to come. I mean, there's a lot of things going on there, right? And we can't list them all, but there's a lot
Right.
of things that
There's
the EEOCs, right? The Equal Employment Opportunity Commissions, they are in charge of making sure that our employees are not being discriminated in the workplace.
Yeah. So why the history lesson today?
Yeah, I mean, because, Chuck, there's a lesson in every story. Today's story centers on one of the protections provided to all of us by the Civil Rights Act of 1964, the right not to be discriminated against based on our national origin or the origin of our family members. As you know, most Americans immigrated to our country at some point in their lineage, right? Sometime. It was so funny. This weekend, I had a chance to visit my mom, and we were going through some paperwork, and I pulled up um, these family histories that her grandfather, my great grandfather, had written about our family, right? And so it told us about all of our relatives. One of our relatives, the original relative to the United States, was here before the United States was even a country.
Wow. Wow. What was it? John Bodivius Thalheimer the first. I don't know.
Yeah, no, it was actually a Finch.
A Finch.
Yeah, and I don't remember the first name. A Finch.
Yeah.
Yeah.
Well, my families are immigrated. Both my grandparents came from, I guess, the old country, so they immigrated here also.
That's kind of cool, right? I mean, it's cool. And I think all of us have a sense of pride, right? From our heritage and what we get and what we learn from that and our family traditions. It's really part of who we are. But through the years, people have been discriminated against because of their heritage. And this is one such story.
Okay. I cannot wait to hear about it. You know, it is interesting in that when we're talking about family heritage, we're talking about national origin discrimination, sometimes people get that confused with race or color. Okay. And they don't, and this is great. I'm so excited you're sharing a national origin story because you don't hear these too often. So I'm really looking forward to you digging in further on this.
Yeah, and we don't really talk about it a lot. And I think because it's just, it still happens. And obviously, this is one story. There was other stories that I looked at as part of my research. And this one was just the most compelling. But I think that it's happening out there and we just need to be aware of it. So here's the story. Here's the beginning of the story. So the company, and it was actually two companies, Alden Short Incorporated and Hinson Jensen LLC, after the fighting the lawsuit from the EEOC, finally ended up settling. But this story isn't about them. This story is about Claudia Gardiola, Linda Spears, and Letitia Stewart. These three ladies worked at a proper managing company owned by Short and Henson, the two individuals. Gardiola worked for the company as a controller from August 2016 to November 2016. Stewart worked as a mortgage administrator, and Spears worked as a bookkeeper. They were all high-level professionals within this organization. And according to the EEOC, all of them voluntarily quit their job due to a hostile workplace environment caused by not only the two owners, but also the chief operating officer as well.
So they quit on their own. So there's no constructive discharge. They weren't forced out.
Yeah, right. So again, when an employee quits, right, we want to look, did they make that decision on their own? Or was there no other way to go about it? And you have talked about this on numerous of our podcasts about, hey, what do we need to do and how do we need to do that, right? And so again, being aware of that. But there was clear case, in this case, of hostile work environment. The owners and the chief operating officers, both of whom had management authority over Gardolio, Spears, and Stewart, would make comments about Mexicans, relying upon stereotypes and criticizing the intelligence of Mexican people.
Their national origin, or at least their family members' national origin.
Yeah, and so we don't know the history. We don't know were they first generation, were they second, third,
Yeah.
fourth generation, maybe fifth, maybe seventh. We don't know that. It doesn't say that in the case. But again, it was a national origin. The harassment wasn't only general comments about Mexicans, it was also directed at the three ladies using slurs, vulgarity, creating a hostile workplace. In one instance, the chief operating officer told one of the ladies that he could treat her any way he wanted because she was Mexican.
Yeah. So, oh man. So, as a reminder to our listeners, for the EEOC to prove hostile work environment, the claimant, the person saying, I've been discriminated against, must belong to a protected group. In this instance, national origin. Okay, in this case, that they were subject to the unwelcome harassment and comments from their supervisor. So the harassment would need to be sufficiently severe or pervasive. Pervasive meaning it happening all the time, a lot of times, to alter the terms and conditions of employment. And so I'm assuming, Johnny T, that the EEOC was able to prove all of the above, right?
Well, yeah. And so what's fascinating, right? So it took a while for the defendants to use because the defendants used all the legal tactics to slow down the procedures, right? So they left the company in late 2016. The court case started in 2017 and did not end until 2023. 5 years.
I cannot imagine the legal fees for that on the company side, but that is definitely a long time.
Yeah, I never even thought about that, right? But they had that, and they had 3 lawyers that were working for them, and so think about the cost of that, and putting those things in and doing those things and running those things can be a lot, right? And so, but the EEOC doesn't stop, right? I mean, they continue to pursue those things. They want to get a resolution for the employees.
Our tax dollars at work, absolutely. So, but in this case, for a just cause. So what happened?
Yeah, so as mentioned above, the company settled with the EEOC. But let me ask you a question. Would you, as an HR director, rather pay a fine or deal with the EEOC for 3 years?
Wow. I mean, the easy answer is pay the fine and move on. Unless for some reason I felt like we were right. We had but I got to tell you, John, for something to last 3 years, probably we as a company are not right. So the recommendation is pay the fine. Let's move on, put it behind us, get it out of the way. So there we go.
Yeah, right. Yeah, no, I think everyone kind of feels that way. Like, let's just pay it. Let's get out of here, do it. But a lot of cases, in this case particularly, they didn't have a choice, right? They had to sign a 3-year consent decree settling the lawsuit, which prohibited future discrimination, of course, right? In addition to paying $85,000 in damages to Hispanic employees, they were also required to develop and implement a new employee handbook, right? And provide all employees with annual training on discrimination.
Wait, okay. I'm sorry. I just got 6 years of lawsuits. All they had to do was pay $85,000 in damages, consent decree, hey, no discrimination, let's do a new handbook, let's do annual training. This had to be way more than $85,000 in legal fees. So I mean, I will say all good things. Oh yeah. And things they should be doing, but being on the EEOC radar is never a good thing. And I'm wondering, what do you think the lesson is here? It's obvious Is it as obvious as not discriminating against people based on their national origin? Is it that obvious?
I mean, hopefully, right? Hopefully that's not a lesson we don't have to learn, right? I mean, just hopefully that's there. I picked this story for two reasons. One is because we don't often talk about national origin, as you said earlier. And I thought it was a good reminder to ensure that our listener companies are not unintentionally discriminating or harassing employees based on their national origin, accent, or ethnicity, making sure they're not doing any of those things.
Yeah, I often tell a story in our classes regarding a resort in Texas that the ownership came in, new ownership came in, and the banquet employees, setup employees were all Hispanic and Mexicans, and they basically told them you should not speak. They didn't say don't speak Spanish. They said don't speak that foul language, that sort of thing around here anymore. We should have less Mexicans here because Mexicans are always slow. I mean, those are things that people may have these weird perceptions as they say these things. That's national origin discrimination. And it also intertwines with the Immigration Reform and Control Act, which makes it illegal for an employer to discriminate based on an individual's citizenship or immigration status, right?
Yeah, I love that reference. I love that you pulled that out. Such a good thing, because I think a lot of the times people fall into, that's immigration status, that's citizen status, but there's also that national origin. So that's a really good, nice pull up on that.
Nice pull up, yeah. So look, early on you said there were a couple of reasons. What was the second reason you wanted to do this story?
Yeah, and so in the lawsuit, the EEOC called out, and I want to quote this to get it right. At the time, the Guarderio, Spears, and Stewart were employed by the defendant employer, right? And so by that company, there was no human resources department, nor designated an employee to whom complaints of discrimination could be made. There was also no training on harassment or the laws against employment and discrimination, and no employee handbook informing employees of their rights and responsibilities or the procedure for raising workplace complaints.
Ha ha! There it is. Boom. The lesson. You need to have someone managing the human resource responsibilities and functions in your organizations. What do they say? Mic drop. Done.
Yeah, and it's like, look, the more I work with you, Chuck, and the more I work with other HR professionals, the more I realize how important it is of having someone designated to manage the company's interactions with employment law, create best practices to protect the organization, and advocate on behalf of the employees.
Yeah, listeners, let me say the HR professionals and practitioners, talk to your business owners. Make sure they understand the power of having an HR person or just a person to protect the organization.
Yeah, and I think that's so important, right? Having somebody there doing that. And I would add that training your leaders from the top of the organization down to your frontline supervisors in employment law is critical to the health and well-being of your company and your employees. We probably don't say it enough, but the underlying goal of this podcast is ensure companies are getting HR right.
That's right. Spoken, the true word from the pulpit. Preach it, Brother John, or whatever we might say.
Yeah, whatever we might say, right? And so we know, right, Chuck, us at the team at HR Stories, we love coming to organizations and training your leaders to be better advocates for HR by teaching them the law and their responsibilities. Here's the underlying thing that I tell every HR person. When your supervisors get HR right, HR becomes easier and better in your organization.
Yeah, and less scarier and less complicated, which is why we wrote the book, The Ultimate Guide to HR. We made it into checklists, and you can also reach out to us, contact us at team@hrstories.com. Contact us, team@hrstories.com. Links below in the story notes.
You've been listening to the HR Stories podcast.
Wait. Make sure you tell your HR connections about our podcast, because we want to help as many businesses as possible. Also, once again, folks, if you haven't done so, our Facebook group, you've got to join it. John, I'm sorry, I get excited. You've got to join our Facebook group, the HR Team of One community, over 3,500 HR practitioners working together to get HR right. Okay, now, go.
Ladies and gentlemen, you have been listening to the HR Stories podcast, where there is a lesson in every story. Thank you for listening to the HR Stories podcast. The material presented in this podcast is for informational purposes only. Chuck and John always recommend using an employment lawyer or HR consultant to handle any legal concerns or HR issues. We do our best to double check sources and make sure the information we are providing is accurate. We may eliminate or embellish without changing the basic narrative to make the story easier to understand. In certain circumstances, we may change identifying information to protect the innocent. The HR Stories broadcast is brought to you by the team at HR Stories. The team at HR Stories is designed to help anyone with HR responsibilities be better at managing the employee experience. To engage with us, go to the hrstoriesteam.com and learn more about how the team at HR Stories can support your business or nonprofit. Thank you for listening to the HR Stories podcast, where there is a lesson in every story.